Hi, I'm Fred Satilli. I do a lot of public speaking, and when I do, people always ask me where I get all this information. A great many times, people want footnotes. As you know, we've recently published The Future is in the Past, and people ask me for footnotes. They want footnotes. Where did you get this? And then when I begin to tell them where I got it, the next question always is, well, is there any way I can listen to this while I drive or exercise? Is this available in audio somewhere? And of course, it's not. So what I'm going to do here is I am going to introduce you to the Nitty Gritty Law Library, and this is a fantastic information resource at www.1215.org, and this will be a place where you can go and find out everything. So now, without further ado, I'm going to read the introductory publication of the Nitty Gritty Law Library, and you can listen to this and you can follow it up with research through the website. This publication starts with the Serenity Prayer. God, grant me the serenity to accept the things I cannot change, and the courage to change the things I can, and the wisdom to know the difference. In 1776, Harvard University was over 100 years old and privately owned, as were most schools. In the 1850s thereabouts, the first mandatory public school was established in the Boston area. The children were escorted to school by the military over the objection of their parents. From the 1850s to the 1950s, civics, the study of personal rights, was phased out and replaced by social studies and American government. Today, the vast majority don't know the difference between a republic and a democracy, a people and a citizen, law and equity, or even a court of record and a nisi prius court. This booklet and the supporting free website, www.1215.org, is a culmination of 40 years legal research and life experience. We at the Free Library hope your eyes are opened to see the ingenious nature of the Anglo-American legal system, if only it were properly taught. Cut to the chase. According to the preambles of the USA and state constitutions, the people are sovereigns of the country. That is because the people are the creators of government. The created may not dominate the creator. Neither the states nor the central government have any genuine sovereignty. They must operate within the limits of their constitutions, which serve as directives from the people to the governments. The constitutions are not social contracts. The will of the people supersedes the will of the government because the people are the creators of the government. The Seventh Amendment emphasizes that. The will is enforced through courts of record proceedings in accordance with common law procedure. Common law is people's custom and usage since time immemorial. It supersedes statutes and codes, which are defined as equity rules created by a legislature. Statutes and codes are not real law, though they may appear and function as law. Anglo-American law history, a thumbnail sketch. 53 BC, Roman Kingdom, through 509 BC, Roman Republic, through 27 BC, Roman Empire. Legend says Rome was established by the demigod brothers Romulus and Remus on April 21st, 752 BC. The brothers argued over control of the city, but was quickly settled when Romulus killed Remus. Betwixt the 8th and 6th centuries BC, Rome developed into a major commercial power. In 509 BC, the last of 7 kings was deposed and Rome became a republic. The republic lasted until 27 BC, at which time it became an empire headed by Augustus. 43 through 409 AD. Rome controls England, Roman civil law, and Senate. For almost 400 years, Rome imposed civil law on the English subjects, civilians who became civilized. Power was distributed from top to bottom. The system consisted of a legislature that created laws, a praetor that administered the laws and often created his own laws, and the citizens. The praetor was somewhat like a county sheriff who administered the law while standing between the powers that be and the subjects. During the waning days of Rome, the barbarians were allowed to immigrate and occupy government offices. Eventually, the barbarians in the Roman military overcame the Roman structure and imposed their own system. However, there were not enough barbarians to fill the offices, so they had to utilize the existing personnel to administer the vast Roman Empire. Implementation of law of the barbarians was effectively filtered through administrators trained in Roman law. The result was somewhat a mixture in effect. The barbarians introduced the concept of divine right of kings. The king was the first visible source of God's law. Power flowed from the king. It was not possible for the king to break the law. If the king acted contrary to the law, it just meant that for that moment, the king had changed the law. 793 to 1055. Vikings, Norsemen, control England. Common law, the law of the people. Vikings brought to England the concept that power flowed from the people to the king. The king was subject to a jury of Vikings. There were even fewer Vikings than there were barbarians. The existing administrative structure became an imperfect mixture of the 3 systems of law: Roman civil law, the divine right of kings, and common law. Years 1056 through 1216. Emergence of British culture. The next 160 years saw a great refinement of the legal system. One of the most important developments was habeas corpus, which originated in 1166 with the Assisi of Clarendon. The divine right of kings became the dominant philosophy. With the increase of royal power came the increase of royal abuse. The 7th British king, King John, was pushed too hard, and the nobility rebelled. The nobility had enough of King John's private wars, taxes, and conscription of their personnel. On June 15, 1215, some noblemen cornered King John by the Thames River in Runnymede and promised him that they would not cut his head off if he had signed the Magna Carta. He signed it. Later, the noblemen secured the blessings of Pope Innocent III. Neither the king nor the pope intended to honor the document, but they were too politically weak to not honor it. As Providence would have it, by the end of 1216, both the king and the pope died. The new king and pope were not politically well established. The nobility immediately had the king and pope recertify and bless the Magna Carta, and every British monarch has done so since. The Magna Carta radically changed power structure. The Viking philosophy was tentatively reinstated. The king became subject to the grand jury of 25. Still, the road to freedom was rocky. 1297. Confirmatio Cartarum. 81 years after the Magna Carta, it became apparent that an adjustment was necessary. On October 10, 1297, King Edward signed the Confirmatio Cartarum. It locked the Magna Carta as common law upon demand by a defendant. In those days, a plaintiff would go to the law court and sue, with or without a jury, only for money as compensation for his loss. There was no way in law, for example, to stop the city from bulldozing his house. If a non-monetary remedy was needed, he would make a motion for a writ, now no longer required, to allow him to take his case to the king. The king, being very busy, would authorize his right-hand man, the chancellor, to hear the case. The chancellor was busy too, so he would delegate the case to the court of chancery. The chancellor and his minions had all the same divine right of kings authority as the king himself, except on appeal the king would override the chancellor's decision. Because the king or his delegee were making new law tailored to the situation, there was no right to a jury as with law court. 1776, American Revolution. It's a known fact historically, governments grow and grow until they consume their own citizens. On average, they last about 200 years. Many noble persons, such as Benjamin Franklin, tried to stop that pattern for the colonies, but King George would hear none of it. The inevitable happened. Americans rejected British rule, first with the Continental Association, then with the Declaration of Independence. In retaliation, King George canceled all the charters. For the initial years, America, with no legal structure, was run by common law grand juries. Following the Declaration of Independence were the Articles of Confederation, the Northwest Ordinance, and the Constitution of the United States of America. President Abraham Lincoln, an attorney, considered each of the last four documents as a concurrent constitution for the USA. American law. In 1776, the USA continued with the common law of England, but with some significant changes that seriously denigrated the system. First, the Chancery, Equity Court, was procedurally combined with the law court. So far as the Constitution is concerned, they are still theoretically separate, but by physically combining the two courts under one judge, it became easier for judges to control the outcome of cases, which in turn leads to greater corruption. Litigants and their attorneys no longer have a clear perception of when they are at law and when they are in equity. Here's a hint. Statutes and codes are not law. They are equity rules which the judge can enforce, modify, or suspend. The only real law is the common law, i.e., the unwritten custom and usage of the people, which a judge may not affect. Example, see U.S. Constitution Amendment 7. The 1789 Constitution for the United States of America introduced the concept of a republic. One feature is that the people of the United States are sovereign. Sovereign means not accountable to a higher authority. As specified in the Constitution's preamble, the people ordained and created the Constitution for the United States of America, a public corporation. The USA is a public trust located in the District of Columbia. By the way, it's easy to know when a country is actually a corporation. It has a president, secretary, and treasurer. Real countries, such as each of the American states, have governors. One could say that the District of Columbia is the world's 7th smallest country with only 68 square miles of land. A second significant change is that the states are actually countries that have clipped sovereignty, meaning some of their sovereignty was transferred to the federal government. California Government Code specifically states, Section 100A, the sovereignty of the state resides in the people thereof. Section 54950 states, the people of this state do not yield their sovereignty to the agencies which serve them. The bottom line is this: neither the states nor the federal government have any sovereignty of their own. Their purpose is to serve the sovereign people. So how does this all work? You recall that America inherited three systems of law: Roman civil law, divine right of kings, and common law. The people live by custom and usage, common law. Ask anyone, have you ever read any of the laws? Of course not. None have, unless it's a lawyer. People live their basic sense of right and wrong, not because they read a rule somewhere. The legislature and executive branches operate by statutes and codes. That's Roman civil law. The courts operate in one of three modes: divine right of kings, law, and equity. The only law court is a court of record that proceeds in accordance with common law procedure. It is a superior court. The judge has no authority to exercise any discretion. His job is to administer the common law procedure and the laws of the sovereign of the court. In a sense, one could say he is the highest clerk in the court. All other courts, regardless of name, are inferior courts. In the absence of the sovereign power, the judge acts as if he were sovereign, invoking the divine right of kings, subject only to appeal to the sovereign. The judge has unlimited discretion to apply the statutes and codes, change them, suspend them, and make up his own rules. When a case is filed, unless your paper is written otherwise, the presumption is that you are proceeding according to equity rules, i.e., statutes, codes, regulations, and rules of court, but not common law. Sovereignty. The person or body having independent and supreme authority. Webster's New International Dictionary, 2nd edition, 1953, page 2406. In other words, a sovereign is not accountable to higher authority. The Constitution of the United States of America, preamble, acknowledges the people as the creators of the United States of America. A people is sovereign. Preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. There is nothing in the Constitution that authorizes the created entity to commandeer its creator. The USA is specifically restricted. Amendment 9. The enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Amendment 10. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Note well, in legal proceedings, only identify yourself as a people. Never identify yourself as a citizen or as a sovereign citizen. A people is sovereign, is the independent and supreme authority. A citizen is a subject, i.e., a slave to higher authority. Amendment 14, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Remember, you are foremost a people, but you can be a citizen for some purposes and not a citizen for other purposes. The choice is yours to decide any time, whenever you wish. As one of the people, you have all natural rights. You are entitled to all the rights which formerly belonged to the king by his prerogative, so long as you do not encroach on the sovereignty of others. You are outside and above the Constitution. Not all of the Bill of Rights, first 10 amendments of the Constitution, apply to citizens. Civil rights are actually Roman law, civil privileges defined by statute for its citizens. Republic versus democracy. A republic is best explained by first explaining a democracy. In a pure democracy, the people argue among themselves. The argument is resolved by voting. 51 beats 49. Whatever the majority says is imposed upon the minority. The minority has no rights. The majority doesn't need rights. In other words, the sovereignty is placed in the group. It is the group that is not accountable to higher authority. The members of the group are citizens, and they must obey the dictates of the group. In the long run, a democracy becomes a dictatorship of the majority. Except for 2 points, a republic is identical in all aspects to a democracy. In a republic, the people argue among themselves just as done in a democracy. The argument is resolved by voting. However, because each individual people is sovereign, the decision of the majority can only be advice to the individual. The logic is simple. If the group can impose its will upon the individual would no longer be sovereign, and you would no longer have a republic. It would be converted into a democracy. At best, the group is limited to advising the individual. If a group is unreasonable, the individual sovereign is free to ignore the advice. In the long run, a republic leads to freedom for the individual. A democracy becomes a dictatorship of the majority. The other feature of a republic is that the individual may act directly, or he can delegate a task to his representatives. In other words, you can delegate a function to a representative, or, if it's important enough for your judgment, you can do the job yourself. In a republic, that is why you can use the government courts, or you can create your own court. If you create your own court, and a court official, such as a judge, misbehaves or attempts to override you, the tribunal, you can issue a writ of error to rescind his action. Court of record. Court. A stage upon which the sovereign conducts his show so as to satisfy the rest of the world that his decision is a good one. That's the practical definition. The legal definition is the person and suit of the sovereign. Court of record. A court of record must conform to 4 requirements. Power to fine or imprison for contempt. Keeps a record of proceedings, proceeding according to the common law, not statutes or codes, and the tribunal is independent of the magistrate or the judge. You will only find all the above items in the 1st, 2nd, 3rd, and 4th editions of Black's Law Dictionary. The 5th and later editions only show items 1 and 2. The powers that be could not eliminate items 3 and 4 from the law, so they eliminated them from the reference books. As a general rule of thumb, older dictionaries are law-oriented, Modern dictionaries are more policy-oriented. Note, Item 4 says the tribunal is independent of the magistrate or judge. All judges are magistrates. The tribunal is the person who actually makes the discretionary court decisions. The magistrate may not usurp the powers of the tribunal. The plaintiff is the tribunal in a court of record. Let me repeat that. The plaintiff is the tribunal in a court of record unless there is a fully empowered jury, not an advisory jury, as in an equity court. If the magistrate makes a decision, the plaintiff tribunal may issue a writ of error, correcting the magistrate's error. Let me read that again. If the magistrate makes a decision, the plaintiff or tribunal may issue a writ of error, correcting the magistrate's error. Corruption. Power tends to corrupt, and absolute power corrupts absolutely. This is a quote from a man called Lord Acton. Corruption always overrides law. Behind every formal system there is an unpublished informal system. This is as true for the legal system as it is for many other systems. You never know. Maybe the judge gets his advice from his wife or an old school buddy, or is bribed, or maybe the judge does not like you, especially if you're trying to represent yourself. Judges don't like amateurs in their courtrooms. Judicial arrogance is another factor. One thing for certain, all law is theory. The informal system is reality. Backed up by guns of government in America, the judges are gradually organized themselves against the people. See the Anti-Government Movement Guidebook, written by judges for judges. It explains how to minimize the success of pro se litigants. Pro se means speaking for yourself. So I'm going to repeat that. See the Anti-Government Movement Guidebook, written by judges for judges. It explains how to minimize the success of pro se litigants. King Cambyses severely dealt with Judge Simenes, who accepted a bribe in the 6th century before Christ. In 1498, a painting was made of the event. There are also powerful, corrupt, non-government forces at work. Here is the Dodd interview from the Reese Committee hearings. And then here there's a YouTube link, which at some point may work and at some point may not, but you can go to the website and get that link. This booklet that I'm reading is, of course, available on the website, www.1215.org. Anyway, the Constitution provides a weak remedy. In this republic, the individual can invoke his status as one of the people, not a citizen, in a court of record, but it's a hard fight to get the benefit. The only way to minimize corruption is to bring in a higher power, such as an appellate court, Supreme Court, a personal lawsuit against a corrupt individual, street demonstrations, or even revolution, as when the colonies separated from England. And then here's the story of the judgment of Cambyses' flaying of Simenes in 1498 by Gerard David. And this is in the Grinega Museum in Bruges. Simenes, Herodotus tells us, was a royal judge under the reign of King Cambyses II. He accepted a bribe from a party in a lawsuit and therefore rendered an unjust judgment. King Cambyses learned of the bribe, accused Simenes, and had him arrested and punished, but not by some ordinary punishment. The punishment was as creative as it was cruel. King Cambyses slit the throat and flayed off the skin, and he strung a chair on which Sisamanus had used to deliver the delivery of his verdicts with the thongs made of his skin. Cambyses creatively did not stop there. To replace Judge Sisamanus, whom he had killed and flayed, Cambyses appointed Sisamanus' son Otanus as the new judge. Cambyses warned Otanus to bear in mind the source of leather of the bench upon which he would sit to hear evidence, deliberate, and deliver his decisions. No doubt King Cambyses' warning left an impression on the new judge. People's rights versus citizens' privileges. People have natural rights. Citizens only have privileges granted by the government. The privileges are misnomered civil rights. The Supreme Court has applied the doctrine of selective incorporation as the dominant doctrine for incorporating portions of the Bill of Rights for application to citizens of the United States. Amendments available to U.S. citizens: religion, speech, press, assembly, and petition, right to keep and bear arms, search and seizure, double jeopardy, self-incrimination, and just compensation. Protection has been diluted. Speedy trial, public trial, jury trial, impartial jury, notice of charges, confrontation, compulsory process, and counsel, and cruel and unusual punishment. Amendments not available to U.S. citizens: quartering troops in homes, grand jury indictment, jury trial in civil cases, and bail, excessive fines under equal protection. Confirmatio Cartarum, October 10th, 1297. The Magna Carta is common law. Edward, by the grace of God, King of England, Lord of Ireland, and Duke of Guienne, to all those these present letters shall hear or see, greeting. Know ye that we, to the honor of God and of the Holy Church and to the profit of our realm, have created for us and our heirs that the Charter of Liberties and the Charter of the Forest, which were made by common assent of all the realm in the time of King Henry our father, shall be kept in every point without breach, and we will that the same charters shall be sent under our seal, as well as to our judges of the forest as to others, and to all sheriffs of shires, and to all other officers, and to all our cities throughout the realm, together with our writs, in which it shall be contained, that they cause the foresaid charters to be published, and to declare to the people that we have confirmed them in all points, and that our justices, sheriffs, mayors, and other ministers, which under us have the laws of our land to guide, shall allow the said charters pleaded before them in judgment in all their points, that is to wit, the Great Charter as the common law, and the Charter of the Forest for the wealth of our realm. And then there's a health note. If you don't have good health, then nothing else matters. To maintain good health, you need good food, good exercise, and good rest. Here are some helpful tips. And then there are some links to helpful tips on how to stay healthy. And then there's the disclaimer. Nitty Gritty Law Library has no financial or vested interest in any of the references in this book. You are on your own as you pursue them. Honor and dishonor. This is the most important aspect of law. In law, honor and dishonor is a process. It is how you react to a presentment. Throughout the entire process, you must be in honor. This applies to everything you do in the legal process. To act with dishonor towards the other person is the highest sin in any system of law. To honor a presentment, accord and satisfaction, conditional acceptance, rejection without honor. To dishonor a presentment is argument and silence. High principles. In ancient times, honor was the manner of being that we now describe as having integrity. In plain language, an honorable person avoids deception whenever possible, treats others with respect, and sticks to his or her beliefs no matter how others think or act. That's a quote from Carla Joy. Personal integrity, allegiance to moral principles, is available at wordia.com. The ultimate measure of a man is not where he stands in a moment of comfort, but where he stands at times of challenge and controversy. That is from Martin Luther King. The difference between a moral man and a man of honor is that the latter regrets a disreputable act, even when it has worked and he has not been caught. That is a quote from H.L. Mencken. And now attitude. Attitude is very important. Canon law strategy will not work if you have a negative attitude. Many people who are defending their rights are also very angry. Not that they are not justified. However, anger is a luxury of the poor. As the saying goes, don't get mad, get even. The whole court process is about getting even. The reason the IRS does not tax court judgments is because the judgment is perceived as a compensation for what you lost. For example, if you are falsely incarcerated, that time in jail has a monetary value. The monetary judgment you receive is a monetary replacement for your injury, namely, for the right you lost. You need to psychologically detach yourself from your problem. If you don't, if you are too close to your problem, you will be blind to your options. Your mind will be channeled and you won't see other opportunities to win. Ever bought a car? After you bought it, did you notice many cars on the highway were just like yours? Your mind was channeled. This booklet, The Real Law, is a distillation of over 40 years of research and practical testing in court. This hearsay booklet provides a concise set of basic concepts by which you can gain insight into the legal system. Missing from this booklet is the black law letter, case law, and other authority to validate this information. For that, you must view www.1215.org. We at the Nitty Gritty Law Library hope you benefit from this information as much as we have. Well, thank you for listening. That's a brief introduction to the Nitty Gritty Law Library. I hope you will listen to this a number of times and try to absorb the ideas and concepts here. They're critically important, and I certainly hope that you will go to the website and delve into it. It's a vast wealth of knowledge and information. If you absorb everything there, you will not only be very much happier in court, but you will be very much happier and secure in your own life with the knowledge that you are sovereign. It is your birthright, and you really should claim it for you and everyone you love. Thanks again. I'm Fred Satilli. I really appreciate your attention, and I'll be back with you soon. Thank you.